Good morning. My name is Alonzo Taylor. Today's date is November the 18th, 2021. The time is exactly 10:43 a.m. I'm sitting before the computer in my home office here in Stockton, California. And after having a discussion yesterday with a gentleman who informed me that in a decision out of the First Appellate District called Henry Moore, that they had ordered a lifer released without going to board, and I suggested that that could not be possible uh, just based on the amount of time that he had in, was what I was told. I looked up that Moore decision this morning, and as I attempted to relate to the gentleman that I spoke to yesterday, that was not possible because the only way for a lifer to get out of prison is through the board or if the governor commutes the sentence or grants them a pardon. Otherwise, according to statute under 3041, you must be found suitable by the board in order to get released from prison if you have an indeterminate sentence in the state of California. But the Moore decision was based on a misinterpretation by the gentleman who spoke to me. That case is based on Senate Bill 1437, which, for all of you who are aware, that back in 2019, the legislature enacted a change to the felony murder rule in the state of California that holds if you were not the shooter of the individual that was killed or the person that stabbed him or whatever and however their death occurred, and you were just merely present at the murder, and you did not act with reckless indifference to human life, nor were you a major participant in the murder, then you could have the murder vacated and be resentenced. And in this resentencing proceeding, if there was any other target felony offense associated with the case, whether or not that target offense was charged in the information, that the court was now empowered to vacate your murders and sentence you to that target offense that existed in your case. That target offense could be an assault, it could be a robbery, it could be a burglary, it could be any other felony offense. For most of the guys that this is occurring for, the murders are being vacated and they're being sentenced to between 2 and 9 years on these target offenses. Those target offenses include, such as in one case where it was a robbery murder. They resentenced the gentleman to 3 years for the robbery and 1 year for his principal co-defendant having a weapon that he used. So he sentenced him to 4 years. He had 29 years in prison. So that means that he has 25 excess years following this proceeding that ended on June the 11th when the murders were vacated and he was resentenced. I have since filed in the Superior Court, which has been set for December the 16th, 2021, to have a hearing to have the judge find him factually innocent of the murder. By so finding him factually innocent of the murder, we will be able to file with the State Victims Compensation Board and have him paid at $140 a day for those 25 excess years in prison. I have 30 such cases on my caseload presently. 25 of those individuals are out of prison. 5 are going through the process at one stage or another, either in the Court of Appeal, the California Supreme Court, or in the Superior Court, having further proceedings there. This Moore case that this gentleman referred me to, that's what it was based on and how he was able to get out of prison. They argued in the California Supreme Court that he did not act with reckless indifference to human life because he had a special circumstances finding in his case by the jury that found him guilty, which gave him life without the possibility of parole, and or most other people who are sentenced under that statute receive a life without the possibility of parole, if not the death penalty. Mr. Moore, murder was therefore vacated on the principle of SB 1437, and he'll go back before the Superior Court, who will now vacate the murder and then sentence him on the remaining robbery if the court finds that he was a major participant in the robbery. Now, In saying this, I wanted to disseminate this information and get it out there because there's a lot of other people like the brother who told me about the Moore case and that this guy was ordered released without going before the board, and he was under the understanding that it was based simply on the amount of time that he had served. But that's not correct. There has been no court that has found that simply based on the amount of time that a prisoner was locked up, that he was to be released without going before the board and the board entering in their minutes that he is being found suitable for parole. And I wanted to disseminate this right here so that this misunderstanding can be cleared up throughout the system and people know that in order to get out of prison, you either must have a court order that directs that the board hear your case again and set certain parameters that they cannot deny you on, which thereby sets the stage for you to be found suitable, and if the governor does not act to reverse that finding, that you will be released. So all of you who see this tape and hear this message, get at me. If you're in that situation that you fit the criteria for these 1170.95 proceedings, because we're getting you brothers out, we're getting you paid, and we're moving on to collect our reparations that we demand and that we're entitled because of what we've been subjected to these last 50 years in the state of California. And with that, y'all have a good day.